All right, welcome again, Employment Law Show, to all of our viewers in Ontario and Alberta and BC. Welcome to the show. 30 minutes of knowledge that you can really use. In fact, you're going to learn a lot, that we can promise you. Reaching out anytime, we always put it at the bottom of the screen, but just in case, 1-855-821-5900, employmentlawyer.ca or help@employmentlawyer.ca to reach out anytime. John Scholes, along with Lior Samfiru. Basics of severance, in fact, understanding severance pay. We're going to get to that here in just a bit. Lior, and some phone calls from our live radio show. You can find those radio shows at employmentlawyer.ca. And of course, pocketemploymentlawyer.ca. That is a website that is absolutely free and anonymous. You can use that. It's like having an employment lawyer with you at all times. So check it out, if only for interest's sake. And of course, inside Employment Lawyer, or at least Pocket Employment Lawyer, is the severance pay calculator, which so many have relied on for years and years. So check that out as well. But first, week that was, pal. What do you got going on?
Hey, John, always great to be here. Always great to be back talking about employment law and workplace rights. You know, this show, for me, doing it is a privilege, because what I get to do on this show is I get to even out the playing field. I get to teach people about their rights that they may not realize that they have. In fact, I almost guarantee you'll learn about rights you didn't know you have. That's what the show is all about, to teach you and educate you about your employment law rights so that you know what to do the next time there's a problem. If your boss does something or says something, maybe you're faced with the workplace situation, you lost your job, or you're being mistreated, or you're being put on a temporary layoff. Does that all mean? What do you do? Well, this is what we talk about on this show. But you may have a lot of questions that we don't get to answer in the 30 minutes of the show. Not a problem. I'm not going to go away just because we turn off the camera. You can always reach out to me in the office. We'll give you that contact information throughout the show so we can have a private discussion. The law is good. The law really does protect individuals. Employment laws across Canada are quite extensive, and that's what we're here to talk about. And like we do every show, I want to start with the week that was, talk about a situation that came across my desk just over the past few days. Well, John, we talk always about severance, and we talk about why it's so important to get advice, because it can be quite nuanced. Well, I had a good example of this past week. I spoke with a gentleman. He was let go after 7 years of working in a very senior role, executive position. He was offered 6 months' pay, and he wanted to know if that's appropriate. Well, in discussing with him, I found out that he also had signed a non-compete obligation, a non-competition obligation that prevented him from working for a competitor for a year. Now, for most people, and John, we talked about this on the show, for most people, a non-competition obligation may actually not be enforceable. But for him, it was, because he was in such a senior position. So he had a non-competition preventing him from working for a year. Well, why am I mentioning that here? Because of the fact that now he can't really find a job in that industry for a year, that has an upwards impact on his severance. Whereas normally I would have probably assessed him as being owed 9 months' pay, I can now easily say that he's owed a year's pay. If he can't work for a year, he should be paid for that year. So the fact that he had a non-competition obligation increased the amount of severance. And the same may apply to you. You may have signed a non-competition obligation. If you lose your job, that may mean you're owed more severance. But there's other factors that could increase severance beyond what you expect. Maybe you were recruited away from another job. That's going to increase severance. Maybe you're working in an industry where there's just not a lot of jobs now. Well, guess what? That increases severance. Maybe because of COVID-19 now, no one's hiring, or it's going to be difficult to find another position. That increases severance as well. And there's many other factors like that that can increase your severance. That's why we say this on the show every week. We'll continue saying this every week, is do not leave your job. Do not sign off on anything without giving me a call. Let's talk about the severance that you're owed. I can almost guarantee you, in fact, I can guarantee you, you're owed much more than what you've been offered. Do the smart thing, just like this gentleman did, and make sure you stand up for your rights.
You mentioned in this case that the non-compete would stick because he was a high-level employee, a fiduciary, or what you're saying at all times. It doesn't always stick. Sometimes you can, I don't know if ignore it's the word, but it doesn't always have any sort of gravitas when you're being let go.
So what our courts have said is that we don't like things that prevent people from earning a living. Right. So what that means is that for most people, not everyone, but for most people, the vast majority, a non-competition obligation is actually not enforceable. You may have signed it and the employer can't enforce it against you. But you may say, okay, that's good to know. Now I can just ignore my non-competition obligation. Well, not so fast. Because if you signed it, your employer may try to enforce it. They ultimately would lose, but they could take legal action against you. They could cost you a lot of money. They can make your life quite miserable if you're bound by a non-competition obligation and you choose to ignore it. That's why if we have a non-competition obligation, we have to tread very carefully. It's better to engage the company, negotiate an exit or a release from the non-competition obligation. If you ignore it, even though it may not be enforceable from a legal standpoint, you still may get into some trouble.
How about a non-solicitation clause? They often get roped in together, right?
So a non-solicitation clause or non-solicitation obligation prevents you from going after customers or clients of your former employer. Unlike a non-competition obligation, if you signed a non-solicitation obligation, those are enforceable for most people. So if you sign something that says you can't go after customers for a year or two even, that's something you have to abide by. If you're not, you will be on the receiving end of a lawsuit, which is not going to be a good thing. So we have to treat that carefully. And if we have an agreement in front of us and we're not sure what it means, what it does, if it's going to prevent us from earning a living down the road, get some advice before you sign it. Pay attention to more than just the salary, the benefits. If you don't care about it now, you may care about it later when it's too late.
Reach out anytime, as Lior says, 1-855-821-5900, help@employmentlawyer.ca. And employmentlawyer.ca, the website, is where we go to get our first phone call today, Lior, from our live radio show. And we'll get to it right now.
My brother, he was just terminated last week after being laid off. He's been with his company for 5 years, and then he went to a different position for less than 3 weeks, and then he went back to the company after that. The only thing that he signed off was a change in pay rate, but that was it. But he's curious as to whether he's actually a 9-year employee or whether he's a 4-year employee, and what his entitlement would be.
In that 9 years, he only had a 3-week gap?
That's correct.
What was he offered by way of severance?
3 weeks. He's 60 years old, and he's in sales.
It's a little lean.
Well, that's putting it quite mildly. So this issue comes up very often in terms of what is my real length of service? I've worked for a company for this amount of years, but I had a gap. I either left or they let me go. There was a gap in between. What counts here? Well, let's make it very clear. The shorter the gap, the easier it is to ignore. Okay, in this case, 3-week gap or in a span of 9 years, that's nothing. That's absolutely going to be ignored. Employment here is going to be deemed continuous. Obviously, the bigger the gap, the more tricky it gets. We also look at things such as, did the employer explicitly or implicitly recognize your past service when they brought you back? And if they did, then the service is deemed to be continuous. We can ignore that gap that you had. In many cases, yes, we're able to ignore the gap, which means you actually may have more service, more seniority than you realize. And that's especially important when it comes to your severance, because, of course, the more seniority, the more severance you're owed. Now, going back to this question, this person was offered 3 weeks. And by the way, John, that would be completely ridiculous and completely inappropriate, even if the person was only a 3-year employee. Right. He probably would be owed 4, 5, even 6 months pay just as a 3-year employee. But he's a 9-year employee. That 3-week gap is meaningless. So rather than me just tell you how much he's owed, very simply, let's take the information, let's plug it into our good friend, pocketemploymentlawyer.ca, and let's see exactly how much he's owed. So what you're seeing on the screen right now is the results from pocketemploymentlawyer.ca. So we know this person is in a sales role, 60 years old. He has 9 years of service for the reasons that we've just described. So he was offered 3 weeks pay. You can see on the screen he's owed at least a year's pay, somewhere between 12 to 14 months pay. So that's the difference here. With that salary of $58,000, that's a difference of over $50,000. That's why it's so important to get that advice. You saw in a few seconds here, it took us to find out how long or how much this person is owed. You could do the same thing. Just go to pocketemploymentlawyer.ca, free, anonymous, accurate, easy to use. You can find out what your severance is, what it should be, and do not sign anything unless you do that.
I mean, this one seemed kind of easy. 3-week gap is like, that's basically a vacation. The guy basically took a vacation.
Yes.
And he came back to work after 9 years. Now, when you say recognize previous service, does that mean things like they don't put you on probation when you come back, or they just give you your old tool belt and you go back to work like you did before you left? Would that
There's
be like recognition?
a number of ways an employer can recognize service. One of them, as you just said, they don't put you on probation. They would normally put someone new on probation, but they know you, they're bringing you back, so they're not putting you on probation. But again, did they give you back your old salary, your old employee number? Are they paying you like a new employee or someone that's been there before? Are they recognizing you in a service for the purpose of service award? You know, if they're saying you're a 10-year employee, here's your service award, well, they can't later on and say, no, we didn't really mean that. So there's a number of reasons and a number of ways an employer can recognize explicitly or implicitly past service. But the bottom line is, please don't assume that the time you had with the company before, even though there's a gap, don't assume that that time doesn't count. In most cases, it does.
Another good way for you to reach out anytime, terminationquestions.com. You can ask your questions there, and if you're lucky, we'll get them here on the show like we're doing with Charlotte. First one for the day, Lior. Charlotte says, I was laid off 6 months ago. When I asked my employer about a return date, she said she may not bring me back and that a clause in my employment contract gives her the right to lay me off for as long as she needs. I'm 100% confident I never signed a contract when I started. Can she do this?
Well, let's break this down into a few things. First of all, as we've said this on the show before, we've said many times, a temporary layoff in most cases, doesn't matter what province you're in, a temporary layoff is in fact not something an employer can do. It's illegal in most cases in that it allows you to treat that temporary layoff as a termination. That's true always. It's true now during COVID-19. You can treat that temporary layoff as a termination, or you can accept it or say, no, I'm not accepting it, pay me my severance. But what an employer can do is have an employment agreement with the employee that gives them the right to lay off the employee. At least temporarily. So it's not legal unless you sign an employment agreement that gives the company the power to do that. Now, even if you signed an agreement that gives that company the power, it's not like they can lay you off forever temporarily. That would be ridiculous. It depends on the province. There's a number of weeks you can be laid off temporarily, but that's, of course, only if you signed a document that gives them that power. Now, this person, Charlotte, says, no, she never did sign anything. If she did not sign anything that gives her employer the power to let her go or to lay her off temporarily, that temporary layoff is a termination. That temporary layoff now can be treated by her as something that requires them to pay her severance. So the same to you. If you've been laid off temporarily, in most cases, you have that right to pay, to get severance. And in many cases, that may be a lot better than waiting indefinitely, waiting months and months and months to see what the company chooses to do. You can make that decision instead.
Understanding severance pay, we'll tackle that after we take a short break. You want to reach out in the meantime, there you go, help@employmentlawyer.ca. And the number, 1-855-821-5900. Employment Law Show continues. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes and, of course, Lior Samfiru. Reaching out anytime. PocketEmploymentLawyer.ca is a great place to start. And the phone number, 1-855-821-5900. All right, understanding severance pay. Most people think they do. Maybe their friend Steve across the fence thinks you do. But we're going to clear everything up for you right now because there's a lot of gray area when it comes to this, Lior. Termination contracts, severance pay. You heard things like termination pay, pay in lieu of notice, reasonable notice, common law, all these terms. Break it all down. How do they relate to severance pay?
Well, John, what I'm actually going to do, I'm not going to break it down. And here's why. So there's all these terms that people have heard: termination pay, severance pay, notice, pay in lieu of notice, etc. None of those matter. And here's what it really matters. Who cares what the definition is? What we're talking about is the amount of compensation you're owed when you lost your job. As a lawyer, yes, I can differentiate between termination pay and severance pay and pay in lieu of notice. None of that actually matters at the end of the day. If you're owed 6 months, you're owed 6 months. The fact that it's comprised of 2 months of this and 4 months of that doesn't change what you're actually owed. That's an academic exercise for employment lawyers, for you out there. We call it severance. That's just a generic term. What we're talking about is the number of months pay that you are owed ultimately when you lose your job. So don't get hung up on these definitions. It does not matter at the end of the day. If I tell you you're owed 8 months pay, does it matter if it's 3 of that and 5 of this, or if it's 8 of this and none of that? Who cares? At the end of the day, it's what you're actually owed. So a lot of people get very confused, John, because they read up about this and do I qualify for that? Doesn't matter. The amount of compensation that you're owed is based on a number of factors. We're going to talk about that, your age, position, length of employment. To know how much you're owed, the total amount, regardless of what it consists of, you go to pocketemploymentlawyer.ca. You do not need to worry about the definition of termination pay, etc. None of that changes what you're actually owed.
Some of our new viewers a moment ago might have caught you say, might have heard you say, how many months am I owed? Well, Lior's losing it months. I thought it was a matter of weeks' pay. What's he talking about? So how is it truly calculated?
Yes, I hear that often. Do I get 2 weeks or 3 weeks? And the answer could be no. You get 8 months. So no, I haven't lost it. Thankfully, not yet. Maybe one day. For now, I'm still here with it, and I can tell you that the amount that you're owed is always going to be a lot more than what you realize. That's why we do this show. So to know how much you're owed, the main factors are your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the greater the entitlements. But there's other factors as well. We talked about that at the beginning of the show. For example, the industry that you work in, the state of the economy, whether you have a medical condition or not, that could impact your entitlements. If you've been recruited away from another job, if you were treated badly, all those things can increase or potentially even decrease your entitlements. So that's why we created pocketemploymentlawyer.ca. That's why we do this show, because it's not a week per year or 2 weeks per year. It's more interesting than that. And for most people, it's a lot more than that. And by the way, you could have only worked for a few months. You may still be owed a few months' pay. In fact, the number of months of severance could even exceed the months of employment. So please, please don't assume there's a week per year. That's wrong. That's false. And if you believe that, you're going to accept, I assure you, a lot less than what you're owed.
You know, in the first segment, we did talk a bit about employment contracts and how they can change things. How does that contract affect severance, or can it?
So what an employer is able to do in some situations is have an employee sign an employment agreement when they first start working that limits their future severance. So an employer that is inclined could limit someone to as little as a week's pay per year of service. And that could mean a fraction of what the person is actually owed, which is why I always say, when you sign an employment agreement, you're very excited, you signed up, you have a new job coming, you've been looking for a job, and you don't realize that one of the things you're signing off on is minimal severance, giving up your severance entitlement. So be very careful with that. But here's the good news. Even in situations where the employment agreement tries to limit entitlements, in over 90% of cases, it doesn't do that properly. For reasons that I don't need to get into, technical reasons, in many cases, that employment agreement, despite wanting to limit your future severance, does not do that properly. That does not mean we're just going to sign off on agreements without realizing what we're signing. But what it does mean is if you ended up signing an employment agreement and now you're let go, please, please, please do not assume that your employment letter, your employment agreement actually limits your entitlements. Chances are it does not, and you're still owed your full severance. But yes, an employment agreement, in theory at least, could limit someone's severance.
We're talking about understanding severance pay, and when we started this, you mentioned one of the terms that you don't want to concentrate on necessarily, but is working notice. What does that mean?
So working notice, an employer can pay severance or they can provide advance notice equivalent to that. So an example, if someone is owed 10 months severance, one of the ways that the employer can meet that obligation, instead of paying someone out for 10 months, is they can give that employee 10 months advance notice. We call that working notice of the termination of their employment. So if they give the sufficient number of months notice, at the end of that notice, they're not going to owe the employee anything else. Now, here's the thing. In most cases, an employer doesn't provide a lot of notice. Not too many employers are going to say, we're telling you today that 10 months from now, you don't have a job. So that may not happen. But even in a situation where the employer does provide advance notice, in many cases, if not most cases, it's not enough notice, meaning the employer still has to make up the difference at the end of it. All right? But yes, at least in theory, an employer can provide notice instead of paying severance, keeping in mind, of course, that if you leave before your last day, that's considered a resignation, and then you would not be owed any severance.
What if we take the case of hourly workers, part-timers, contractors, construction workers? That comes up all the time. Are they owed severance the same way as well?
Yes, 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 and yes. Absolutely yes. So there's all these misconceptions. You've named them. Construction employees, part-time employees, hourly employees. Do they get severance? Of course they get severance. Yes, I said construction too, by the way. Big misconception that construction employees don't get severance. Nonsense. Not only do they get severance, they get the same number of months' pay as anyone else. You can go to pocketemploymentlawyer.ca to see how much you're owed. Oftentimes, people that are misclassified as independent contractors think, well, I don't get severance because I'm a contractor. Because the law may consider you to be an employee. The law makes that decision, not me, not you, not the company that you work for. So if you've been misclassified, but you truly are an employee in the eyes of the law, you're going to be owed severance. Like I said, construction employees, the fact that you're a part-time employee does not mean you don't get severance. Of course you're owed severance. So if you have a job and you lost a job, you're owed severance. It's literally that simple. And as I said before, to find out how much that is easily, anonymously, within seconds, pocketemploymentlawyer.ca.
So I've been terminated, got a severance letter, I got a severance offer. How can a lawyer like you help? Can't I just go in there and say, give me more? Because I think it's wrong because I checked pocketemploymentlawyer.ca.
The reality is that to get more severance, in most cases, you would need some assistance because an employer may not want to pay more because they may not realize they have to, or they may simply think you won't do anything about it if they don't. So the first step is to get that advice to find out how much you're actually owed, the real amount of severance that you are owed. That's the first step. Once you do that, to negotiate proper severance, for me, for my team, that's not difficult. It doesn't require going to court. It doesn't require months, and it doesn't require a lot of money. None of those things are true. In most cases, 1 or 2 letters from me or my team will do that. So don't be afraid of the process. Don't be scared about what it's going to involve. And by the way, we can do that often without burning any bridges with your former employer. We're going to be respectful. We're going to be non-threatening, but we're going to remind the employer, here's what your obligations are, and we expect you to meet those obligations.
Reaching out, by the way, if you want to carry forth with Lior and his team, 1-855-821-5900. And employmentlawyer.ca is the website. You can catch our radio show and where to find it on that website. Phone call number 2 from the radio show is coming up now, pal.
Just before all this COVID stuff happened, I was let go by my employer. The reasoning they put on my form was non-constructive dismissal, which I've never heard of before.
Neither have I.
They just deposited in my account a severance pay. It was probably about a month's pay.
So how long did you work there for, by the way?
Just under 5 years. So I never signed anything. I never accepted no payments, no nothing. They just deposited it into my bank account.
Well, that term non-constructive dismissal is something that was made up by the employer. It doesn't exist. There's such a thing as a constructive dismissal, which is a change to the terms of employment that results in a termination, or a regular termination, which is just you being let go. Now, this person was actually let go, so it's really about severance. So he was paid 1 month's pay after 5 years. Again, depending on his age and position, anywhere from 6 to 8 months, 6 to 9 months is what he'd be owed. So many times that. But there's an interesting reminder here because the company paid him the money and he's probably very worried. Wait a second, I took the money, it's in my bank account now. Am I now considered to have accepted this? Am I now considered to not be able to go after my full severance? Well, don't worry about that. If the company pays you money and you take that money, as long as you didn't sign anything, it's fine. You are not prevented from going after your full severance. If you do sign off on that severance package and then the company now can rely on that signature, that's a problem. So you do not sign off on it, but it's okay to take the money if it's paid to you, and then let's make sure we get everything that we're owed.
Reduced pay after maternity leave. Want to talk about that, but first we've got to take a break, so we'll do that first and come back and talk about it. 1-855-821-5900 and employmentlawyer.ca. It's the Employment Law Show.
You were being harassed, and when you said something about it, You're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back, Employment Law Show. You want to go to employmentlawyer.ca. That is the website to check out our radio shows. Have a listen to those. Been doing that for about 8, almost 9 years now. So you'll catch those in most locations. If you tune in and listen to that hourly show, we take a lot of phone calls on the radio show. Lior, we'll get to phone call number 3 right now.
I'm currently on maternity leave, and I've wanted to contact my employers to see about extending my maternity leave because my industry has been devastated by the COVID. They wrote back and said, yes, that's fine. Actually, it suits us very well. And by the way, when you do return, there will be cost-cutting measures, and you may be doing a different job or at a lower rate of pay.
So bottom line is that right now an employer has to protect your job for 18 months. Anything beyond that, they may agree to give you more time. In other words, we're not going to let you go if that's what you want, but they don't actually have to protect your job in the same way. So that job protection only applies for those 18 months. So what we don't know here is maybe she wanted to take a year and then wanted to extend it to 15 or 16 months as an example. In that situation, the company would have to take her back to the same job and the same pay, and it's not up to them. They have to. On the other hand, if she has been in 18 months and she wants a few more months, she doesn't have the same protections. But the general rule with the maternity leave is this. Not only can you not be fired because you took a maternity leave or parental leave if you're a father, you have to be taken back to the same job with the same compensation, same responsibilities. Company can't decide to keep your replacement. That would be a breach of the Employment Standards Act. It'd be a breach potentially of human rights laws. So if you're ever in that situation, you really have to reach out to me as soon as possible.
I think we got time just to bounce over to termination questions one more time, Lior. This one from Howard says, I've worked with a large company for 8 years under consecutive 2-year contracts. The new contract they want me to sign states that I will be paid 20% less due to COVID-19. If I refuse, they will not renew, and I will not receive a dime. Is that right?
So consecutive contracts, that term was just used. Yep. Generally speaking, here's the rule. If you sign more than 3 of these consecutive contracts, the law says those contracts become meaningless and you're now a regular employee. So if Howard signed more than 3 contracts and the company now wants to let him go, not to renew, they have to pay him severance. He's been there for 8 years. He could be looking at 10 months pay or even more. So he's owed severance. The decision he has to make is this. Does he want to continue working with reduced pay, or does he want to get his severance? The concern with taking the reduced pay is this. If you take the reduced pay, you potentially have given them the right to do it again and again and again. And also, if you take the reduced pay and then a month later they let you go, the severance that they have to pay you is now based on the reduced pay. So he may be better off to say, I am not signing this. I'm not agreeing to a reduction in pay. And if they do it anyway, he can get his full severance. He can treat that as a termination and not take any discounts.
If he does do that, he also needs an employee after 3 contracts, and he does get let go. Does the severance start way at the beginning from his first contract or from after the 3rd contract?
It starts way at the beginning.
Okay.
So if you signed your first contract was 20 years ago, well, your severance is going to be based on the last 20 years. So 3 is usually that magic number. If you sign more than 3 contracts, it becomes meaningless. You're no longer on contract. You're now a regular employee, and your severance has to be based on you being a regular employee.
Lots to take care of there, lots to talk about. If you want to reach out, you can, no problem. Now that we're done for another show, 1-855-821-5900, help@employmentlawyer.ca. That is the email address. And Lior referred to it several times and will continue to do so on every show. pocketemploymentlawyer.ca is the website. Inside there, the severance pay calculator as well. Thanks for joining us. We'll catch you next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.